So just as a reminder before we get started, your papers are due tonight by 11:59 p.m. in Blackboard. Any last minute questions on the paper? You guys are just ready to be done with it? Yeah.
You can cite documentaries, right?
Yes. Documentaries are fine. Yeah, films, YouTube, that's fine. Yep. Okay. So we're going to talk about the third branch of the government, which is the judicial branch. We're going to talk a little bit about how our legal system works, a couple different types of federal courts, and then, of course, the biggest one, the U.S. Supreme Court. So we're finishing with the branches of government today. Okay, so overall, in our entire legal system, you can see it divided into two categories, criminal and civil cases. With criminal law, this is where someone is charged with violating laws relating to health, safety, or morals. So for example, shoplifting or assault, rape, etc. In a criminal case, the government is always the plaintiff. So they're the one who always brings the charges. So it's the state of Texas versus someone, or the United States government versus someone. So in criminal cases, the government brings the charges. In civil cases, the government can be the plaintiff or the defendant. And this is where you see cases dealing with disputes over things like contracts. If a company fails to provide a service, if you hire a contractor to put an in-ground pool in your house, and then they take the deposit and run, that's a civil case. If your landlord refuses to return your security deposit, that's a civil case. So usually the punishment is a fine of some kind, getting back your deposit, getting compensation. And in both civil and criminal cases, you'll see courts looking at prior cases in a similar case to decide what to do. So if this company has been sued before, they may look at the outcome of that previous case. Or if you have two similar cases dealing with a robbery, and in both criminal and civil cases, the Constitution can be cited. It's often referenced in criminal cases, talking about, for example, a violation of someone's Fifth Amendment rights or Eighth Amendment rights. Alright, so in terms of criminal cases, the first court to hear the criminal case is the trial court at the local level in Harlingen or Weslaco or San Antonio. And here A defendant can choose to have their case tried before a jury or before a judge. For some defendants, they may worry that the evidence would be enough to get a conviction from a jury. They may choose to go before a judge, because the burden of proof can be a little higher if you're presenting the case before a judge. So you have the choice. You can take your chances with a jury, or you can ask for a bench trial where it's heard before a judge. If a defendant is convicted, they can take it to the Court of Appeals in their state. The Court of Appeals does not hear testimony. No witnesses, and they don't usually look at new or additional evidence. What they're looking at is, was a legal error made in the lower court? So, for example, did the prosecution not turn over evidence to the defense? Or did the defendant ask for a lawyer at the police station, but they weren't given one? If they see sort of legal error, then they can vacate the conviction and either send it back for a retrial or call it the end of the case. If the defendant loses at the Court of Appeals, he or she can take it to their state Supreme Court. And usually, the state Supreme Court is the final court of appeal for most cases. Usually, that's the end of the line. And courts have certain jurisdiction over different areas of the law. Federal courts have jurisdiction automatically if it involves federal law, treaties with another country, a constitutional issue, or if the government is involved in the case. The Supreme Court has jurisdiction in a case involving the U.S. government and a state, two or more states. So if Texas is New Mexico, that's going to the Supreme Court. A case involving a foreign minister or ambassador, and cases involving citizens from different states or a citizen against a foreign country. So if there's a question about diplomatic immunity and whether or not to try a diplomat, it's going to go to the Supreme Court. But at every level, you have due process of the law. The government cannot deny you the right to a lawyer if you ask for one. They cannot deny you the right to protect yourself from self-incrimination, to see the evidence. There's also the fundamental right of habeas corpus. You have to be formally charged with a crime. You have to be brought to a court and charged officially with a crime. If there is not enough evidence, the court can have someone released. So they can't just hold you indefinitely in jail. They have to bring you before a judge. You have to be charged, and if there's enough evidence, you have to be tried. The right to habeas corpus can only be suspended if we are invaded or if there's another civil war. So if the government in Texas throws you in jail for 6 months and doesn't bring you before a judge, that's a violation of due process and habeas corpus. and the case would probably get tossed out. So in terms of some of the federal courts that we have, 2014 to 2015, the federal courts received a little over 376,000 cases. They hear a lot of challenges to state law. For example, attempts at circumventing Roe v. Wade, or challenges to executive orders. Those get taken up by the federal courts. There are 94 federal district courts and a little over 678 federal judges. Federal judges are appointed. We don't usually hear much about their confirmation process because it's almost automatic. If there's a vacancy, someone gets nominated and the Senate usually just pushes them through. There's also 11 regional courts and the DC Circuit Court, plus 12 U.S. Court of Appeals. The number of judges will vary between 6 to 28, depending on the workload. In a smaller regional court, there just won't be as many cases. But if you're handling states like Texas, California, or Arizona, you're going to need more judges. And the decisions made by these courts are final unless the Supreme Court takes up a case. But because it's very rare for the Supreme Court to take a case, most cases end here. When Louisiana tried to pass a bill that would essentially outlaw abortion as early as 6 weeks, it was a federal court that struck it down, not the Supreme Court. So challenges to state law often end at the federal court level. They don't necessarily make their way up to the Supreme Court. All right, now we've come to the big kahuna, the U.S. Supreme Court. There are 8 associate justices on the court, 1 chief justice. The current chief justice is John Roberts. He presides over the court's public sessions, and he is the first to speak and the first to vote when the justices deliberate. However, his vote does not count for more, and obviously he can't force the other justices to agree with him. And Congress controls the number of justices. There used to be 6 Supreme Court justices. In 1869, they expanded it to 9. So this is why we heard some discussion during the presidential debates about whether or not Joe Biden would try to increase the size of the Supreme Court. Congress could choose to do so. They could add 2 justices, 4 justices, Um, that number 9 is not set in stone. So yes, hypothetically, if Democrats got control of the Senate, they could probably try to add 2 or more justices to the court. You don't want an even number because you don't want the court deadlocking. So that's why it went from 6 to 9. So yeah, if President-elect Biden did get control of the Senate, they could try to do that. He hasn't said that he will, and he also hasn't said that he won't. So who knows? It could change, it might not. Constitutionally, the way it works is if there is a vacancy on the Supreme Court, the president nominates someone and the Senate confirms. It only takes a simple majority to confirm a nominee. And you'll see the senators from the nominee's home state tending to be supportive of their nomination. There's no formal qualifications to serve as a federal judge. Usually, they look for someone with extensive legal experience and good character, and more recently, unfortunately, someone with similar ideological views as the sitting president. So what this means is that the process to appoint a new Supreme Court justice has become extremely partisan. Democrats don't want conservative justices on the bench. Republicans don't want liberal justices on the bench. So the party that has the majority usually just rams through the new Supreme Court justice. As we saw with what happened with the new Justice Amy Coney Barrett. No support from the Democrats, but Republicans had the majority, so she got on the court. And there have been contentious appointments. When Clarence Thomas was nominated by President George H.W. Bush, there were accusations that he had sexually harassed an employee of his named Anita Hill. She testified before the Senate. She was asked questions that should never be asked, and Justice Thomas was confirmed anyway. Then we had, of course, when Justice Scalia died in February 2016, and President Obama nominated Merrick Garland. Merrick Garland is a moderate judge well-liked by Democrats and Republicans. But Mitch McConnell and the Republicans in the Senate said, we don't want to have confirmation hearings until after the election. Nowhere in the Constitution does that say that that has to happen. All it says is if there's a vacancy, the president shall nominate and the Senate shall confirm. So Senate Republicans should not have blocked that process. But they did, and Garland was not put on the Supreme Court. And of course, this came up again after Justice Ginsburg died, and Republicans said, we need to fill the vacancy, and Democrats said, well, if you weren't willing to do it 8 months before the election in 2016, why are you willing to do it less than a month before the presidential election now? Because they're playing games with it, unfortunately. Okay, so I'm going to show you all a video of some of the absolutely ridiculously awful questions that Anita Hill was asked by the Senate in 1991. And you will recognize a few of the faces on this committee. So, yeah.
Welcome, Professor Hill. Can you tell the committee what was the most embarrassing of all the incidences that you have alleged?
You testified this morning that the most embarrassing question involved, this is not too bad, women's large breasts. That's the word we use all the time. You testified you drew an inference that Judge Thomas might want you to look at pornographic films, but you told the FBI specifically that he never asked you to watch the films. Is that correct? The fact is, flatly, he never asked you to look at pornographic movies with him. Quote, this is not too bad, I can read it. Thomas liked to discuss specific sex acts and frequency of sex. Close quote. You said you took it to mean Judge Thomas wanted to have sex with you, but in fact, he never did ask you to have sex, correct?
No, he did not ask me to have sex. He did continually pressure me to go out with him, continually. And he would not accept my explanation as one as being valid.
So that when you said you took it to mean we ought to have sex, that was an inference, a mere allegation.
Senator, I would suggest to you that for me, these are more than mere allegations. These are the truth to me. These comments are the truth to me.
I'm not questioning your statement when I use the word allegation. I know about sexual harassment and discrimination against women, and I think I have some sensitivity on it. How reliable is your testimony in October of 1991 on events that occurred 8-10 years ago? How sure can you expect this committee to be on the accuracy of your statements?
I guess one really does have to understand something about the nature of sexual harassment. It is very difficult for people to come forward with me.
I've got to determine what your motivation might be. Are you a scorned woman? Do you have a militant attitude relative to the area of civil rights? Do you have a martyr complex? The issue of fantasy has arisen. Are you interested in writing a book?
It is appropriate to ask Professor Hill anything any member wishes to ask her to plumb the depths of her credibility.
You are not now drawing a conclusion that Judge Thomas sexually harassed you.
Yes, I am drawing that conclusion. That is
But I
my
don't understand. And I don't understand. Do you have anything to gain by coming here? Has anybody promised you anything by coming to this story now? The witness did not say anything to the FBI about the described size of his penis, the description of the movie Long Dong Silver, about the pubic hair in the coke. I did think that Senator Specter pointed out some inconsistencies. All we've heard for 103 days is about a most remarkable man, and they scoured his every shred of life, and nobody but you has come forward. If what you say this man said to you occurred, why in God's name would you ever speak to a man like that the rest of your life?
That's a very big question. And I'm sure that I cannot answer that to your satisfaction. That is one of the things that I have tried to do today. I have suggested that I was afraid of retaliation. I was afraid of damage to professional life. And I believe you have to understand that this response, and that's one of the things that I have come to understand about harassment, that this response, this kind of response is not atypical. And I can't explain. It takes an expert in psychology to explain how that can happen. But it can happen because it happened to me.
Well, it just seems that so incredible to me. That is the most contradictory and puzzling thing for me. I do not know how Thomas defends himself.
I do apologize to the women of America if they got the wrong impression about how seriously I take the issue of sexual harassment. I must tell you, I must tell everyone else, I take sexual harassment seriously.
Okay. So she went through rounds and rounds and rounds of that questioning, and then of course, Justice Thomas ended up being confirmed anyway. But some of the things they're talking about, like the pubic hair in the Coke can, supposedly he left some of his pubic hair around the opening of a Coke can of hers, which don't even get me started on how gross that is. I have no idea why, but that's the kind of thing she was talking about. I mean, obviously, we hopefully wouldn't see that kind of behavior towards witnesses today, but we did see some similarities in the Kavanaugh hearing process. So sometimes it can get really, really ugly. Not always, but sometimes. Okay. One of the main areas the Supreme Court takes action in is in terms of judicial review. Judicial review gives them the power to examine and overturn actions by the legislative and executive branches. So they can strike down laws, executive orders, policies from various cabinet departments. So in 2012, the Supreme Court did confirm the Affordable Care Act as constitutional, saying that it was part of Congress's power of taxation. The Supreme Court will also use the Supremacy Clause as necessary. The Supremacy Clause says that federal law is superior to state law. So if there's a contradiction, federal law should supersede state law. So in Brown versus the Board of Education, they made the argument that segregation violated the Equal Protection Clause in the 14th Amendment, and therefore it was unconstitutional. The Supreme Court is also sometimes asked to overturn redistricting if it's too biased in favor of one party, or if states deliberately pack minorities into one district. They can also overturn voter laws. Arizona had passed a law requiring proof of citizenship to be able to register to vote, and the Supreme Court said that's an undue burden on people, you can't do that. And they have expanded rights as technology has increased. In the Riley case, they were asked to determine if the Fourth Amendment applies to technology like cell phones, and they agreed that it does. So if you are arrested and the cops want to search your cell phone, you have the right to refuse and tell them they have to get a warrant. If they search your phone without a warrant or without permission, that's fruit of the poisonous tree and it can't be used against you. So if they want to search your phone, tell them to get a warrant. You are well within your rights to refuse to let them search your phone. We've also taken a look at issues like the war on terror. In the Hamdi case, Hamdi was a Taliban soldier captured in Afghanistan and being held at the Norfolk Naval Base. He was actually born in the United States, but they wouldn't give him access to a lawyer. And so the Supreme Court said, he's an American citizen, he needs to have his civil liberties protected. And the Supreme Court has also ruled that habeas corpus is a fundamental right even for enemy combatants. So you can't lock up Taliban soldiers in Guantanamo Bay indefinitely. They have to be given a trial or they have to be released. So the right of habeas corpus applies even to enemy combatants. So they have restricted the U.S. government in terms of actions towards combatants in the war on terror. They've also reinterpreted the Constitution and the Bill of Rights as needed to expand protections. In the Engel case, public schools were having mandatory Bible readings and prayer resuscitation, and the Supreme Court struck that down as a violation of the First Amendment. You can't force students to recite a prayer, read from the Bible, etc. in public schools, because that's a violation of the Establishment Clause. And they've expanded our civil liberties in cases like Gideon v. Wainwright, where the Supreme Court said the Sixth Amendment gives you the right to a lawyer even if you can't afford one. And also Miranda v. Arizona, where we get the Fifth Amendment protection from self-incrimination. So as needed, the Supreme Court will reinterpret the Constitution to give us our civil liberties and civil rights. All right, so for the Supreme Court to hear a case, it has to be an actual controversy. They cannot rule on proposed legislation or proposed regulations. They can't rule on a possible law. It has to be in place. Also, the parties in the case have to have a substantial personal or economic stake in the outcome of the case. So, for example, when Anna Nicole Smith's husband died and left her the majority of his money, his children sued to block the enforcement of the will, and it actually went to the Supreme Court. Both parties had a significant economic stake, and the Supreme Court sided with Anna Nicole Smith and gave her the majority of his money. So this was an important case because they had to figure out who was getting what. The case also still has to be relevant or in need of resolution. If the facts have changed or the case has already been resolved, the court's not going to hear it. There are some exceptions. Roe v. Wade is an exception to that rule. By the time it made its way to the Supreme Court, Jane Roe had already given birth. So the state of Texas tried to say, well, this doesn't matter anymore because she can't have an abortion. But the Supreme Court said, well, pregnancy is roughly 9 months. The appeals process can take up to 2 years. So it is still relevant because there is no way her pregnancy was going to outlast the appeals process. So something like that, they'll still hear the case. If an individual wants to appeal a federal court decision, they have 90 days from the decision to file what's called a writ of certiorari. Basically what this is a petition asking for the Supreme Court to hear the case. One of the Supreme Court clerks will review this petition and present it to the justices who are participating in a pool to decide what cases to hear. So 4 of the 9 justices have to agree to hear a case. So what this tends to mean is that only about 1% of cases that are filed get heard by the court every year. You have to have some kind of special and compelling reason for the court to hear your case. So it is exceedingly rare for the court to take up a case. Okay, so the justices get to decide what cases, but there's going to be outside influences. If the government is one of the parties in a case, then usually the Solicitor General will represent the government. Also, if an agency wants to appeal their case to the Supreme Court, the Solicitor General has to review the case first. If he or she does not support the agency's appeal, the Supreme Court will not hear the case. There's also interest groups and individuals who can file what's called an amicus curiae brief. If you have a vital interest in the outcome of the case, you can file a petition asking the court to hear the case and explaining what side you think the court should take. There's also the role of the Supreme Court clerks. Every justice gets 4 law clerks. These are usually the top law students at the top law schools, Harvard, Yale, Stanford, and so on. So they work closely with their justice, and they'll look at these petitions, and they'll provide their opinions, and they'll say, Justice Kagan, this is really something I think we need to hear. And they can appeal to the justice using their personal opinions, personal feelings about the law. And interest groups do sometimes get involved. The NAACP will get involved in civil rights cases. The NAACP combined 4 separate cases into one for Brown versus the Board of Education. So they'll encourage complaints, they'll combine cases as necessary, and they will fully fund the cost. So the parents in the Brown case had representation for free. The NAACP paid the court costs, etc. And the ACLU gets involved in civil liberties cases. If someone's right of habeas corpus has been violated, or their ability to exercise freedom of religion, then the ACLU will get involved. So they're two of the most active interest groups in terms of federal court cases. Okay, so the Supreme Court agrees to hear a case. Then the attorneys for both sides will file a brief with the court explaining why the court should rule in their favor. And they will often cite previous Supreme Court decisions to support their argument. Interest groups can get involved here and file amicus curiae, basically friend of the court, briefs to support the parties involved. Then there is the oral argument. Each attorney gets 30 minutes to present their case, but it's not 30 uninterrupted minutes. They will be constantly interrupted by the justices. Justice Scalia was known for constantly interrupting. Justice Thomas, he doesn't interrupt as often. So the attorneys have to be quick with their presentation, and they have to be able to get their point across. Oral arguments are audio recorded, but no television cameras are allowed inside the Supreme Court. Just kind of as an extra layer of action. So there's always an audio recording, but there's no film. Arguments are open to the public. If you happen to be in Washington, D.C. when the court is in session, you may be able to sit in on one of the sessions. After the oral arguments, the justices then go into their private chambers to discuss how they're going to reach a majority decision. The conferences are only attended by the justices and their clerks. And these discussions, we don't usually know much about them. They're completely private for a reason. Once they have reached a decision, then they have to write the opinion of the court. The opinion is often written by the Chief Justice unless he dissents, in which case he assigns it to one of the more senior justices on the winning side. Opinions are very carefully written because the decisions the Supreme Court makes will filter down to every state and local court. So they need to be very specific. They need to say where this applies, to whom, and how they made that decision. Because it sets precedent for future cases. So they have to be very clear and very specific in their writing. They don't want to open the door for ambiguity. So the majority opinion is written, and the justices on the losing side can write what's called a dissenting opinion. And they do this for a couple of reasons. One, to show that they don't agree with their colleagues. and two, to show the parties that they weren't friendless on the court. So the losers of Plessy v. Ferguson heard that some of the Supreme Court justices didn't agree with separate but equal, and then that came back around in Brown versus the Board of Education. So dissenting opinions tend to be longer because they're hoping that when a similar case comes up, the dissenting opinion will change people's opinions in the next case. So in the Obergefell case, Justice Roberts was on the losing side, and he wrote a very strong opinion saying the 14th Amendment doesn't guarantee a right to marriage, let alone a right for same-sex couples to get married. And he said that his colleagues had basically overstepped their office, that they'd gone too far in their interpretation. So the majority and dissenting opinions are published. You can go to the Supreme Court website and you can read through the entire opinion of the case. Okay, so there's going to be internal and external influences on the court. Sometimes it's something like political pressure. The Supreme Court kept striking down the New Deal programs FDR put forward. And so he got pretty annoyed with them and said, if you're not going to work with me, I'll add 6 more justices to the Supreme Court. I'll pack it with my friends. And the threat was enough to get the court to back off and start supporting the New Deal. It's unclear whether or not he would have actually been able to get that many justices on the court, but they weren't necessarily willing to take that chance. It also depends on the views of the justices themselves. Judicial restraint is favored by more conservative justices like Thomas and Alito. They will argue that the court decisions should be based on a very strict interpretation of the Constitution. That if an issue is not in the Constitution, then the court does not have the right to hear that case. So they would argue that marriage is not a constitutionally guaranteed right, therefore it should be left up to the states. So they tend to see the Constitution as set in stone. The more liberal justices, like the late Ruth Bader Ginsburg and our colleagues Kagan and Sotomayor, look at the Constitution as a living, breathing document open to reinterpretation. They believe that court decisions should go beyond the Constitution. And they argue the Constitution was written over 200 years ago. Society changes, morals change, attitudes change, technology changes. So they think the court should look at the social impacts their decision can have. With Roe v. Wade, it gave women the right to decide if they wanted children or not. With Obergefell, same-sex couples now have the same legally protected rights as heterosexual couples. So they tend to say, we have to reinterpret the Constitution with the changing times. You can't apply almost 300-year-old law to modern society. And of course, there's also the role of the partisanship in Congress. The justices have no say in who gets appointed to the court. They may have their opinions, but they're not taken into consideration. So all they can do is sit on the sidelines and hope that Congress doesn't appoint someone who will turn out to be problematic. And it can change the balance of the court. Right now, the court is leaning conservative. That could change in 10, 15, 20 years and become more liberal. It's constantly shifting. So the court does have its limits. They have to wait for a case to come before them to exercise their power. If you'll notice, Supreme Court justices are very careful not to criticize the president or the actions of Congress, because then they might be seen as biased if that comes up before the court. So they can't exercise their power until someone brings a case before them. Some of the justices might not have liked the Muslim ban, but they can't do anything about it until it makes its way to the courts. The other problem is the decision usually helps individuals and not social groups. There are exceptions like Brown and Roe, but usually it's an individual case where someone's individual civil liberties are violated, and the court limits it to that person or a small segment of society. They don't usually make broad societal decisions. Usually they're helping a small group of people. They also don't have the power to enforce their own rulings. They can't send the military out after anyone. They have to rely on the parties agreeing to abide by their decision, to recognize the power of the courts. But President Jackson was asked to enforce a support order that Georgia released 2 missionaries. The state had arrested on Cherokee land, and Jackson said, "I'm not doing that." If President Eisenhower had chosen not to enforce Brown, we might have had school segregation for another decade or two. Unless the parties agree to abide by the rulings, there's not much the court can do about that. They have to rely on the other branches to help them out, and the power of the court to get people to behave themselves. And of course, the court is shaped by the president and Congress. Again, right now the court is leaning conservative because President Trump has been able to appoint 3 Supreme Court justices. If President-elect Biden gets to replace 1 or 2 people, that might change the makeup of the court. So they're at the mercy of which party's president is in charge and who's in control of the Senate. So they don't really have any flexibility on that. But we have seen the judicial branch expanding its power and expanding our rights over time. In the 1960s, we were told that we had a constitutional right to remain silent, a constitutional right to a lawyer even if we couldn't afford one, the right to have access to contraception. And in the 1970s, the Supreme Court said groups can sue federal agencies. So Greenpeace can sue the Environmental Protection Agency if they're not living up to certain policies. There's also the ability for us to sue public officials for violating our constitutional rights and get some kind of compensation. If someone is wrongly convicted and spends 40 years in jail, more often than not, they're going to get some kind of financial compensation. You can't give someone back 40 years of their life, but you can at least give them some money to get back on their feet. So sometimes someone will sue a state and get something like $400,000, $500,000 in compensation for the clear violation of their rights. So if your rights are violated and you successfully sue the person who violated your rights, you can force them to pay for your lawyer, for the court fees, and sometimes just get some extra money in damages. We now also have the ability to engage in a class action lawsuit. This is a group or class of people with common interests who sue on behalf of everyone who has that shared interest, concern, etc. So one of the first class action lawsuits occurred when a federal judge in New York ruled that Vietnam vets were a class so they could sue the manufacturers of Agent Orange. Agent Orange was a chemical defoliant used to destroy the jungles of Vietnam. Unfortunately, because of how harsh the chemicals were, the veterans were often diagnosed with cancer, lung problems, and there were birth defects that developed in their children. So they were able to sue Agent Orange and the manufacturer for lying about the side effects and how dangerous the drug actually was. So that's why you'll see those ads like, if you took Zantac and you got cancer, now you can sue. It gives people the ability to hold a company accountable, to get some compensation for damages, and to try to pull that product on market. It was discovered about a year ago that the heartburn medication Zantac was causing cancer. It's no longer available over the counter. So it's a way of holding companies accountable, getting compensation, and making sure that product gets off the market so it can't hurt someone else. And while judges can't necessarily throw people in jail for refusing to abide by their ruling, can impose a monetary fine. The NAACP had sued New York City for its failure to build public housing in predominantly white neighborhoods. And in 1985, a judge started imposing fines on the city because they wouldn't agree to build the public housing. The city was eventually fined $1.6 million by the judge until they finally gave in 2007 and said, fine, we'll do it. They could have saved themselves 20 years and $1 million by giving in the first place, but at least it's a form of leverage, and the ability to pressure the parties into doing what you're telling them to do. Okay. Any questions on that? Okay. So one of the concerns we tend to see with the Supreme Court is the Supreme Court is supposed to be above politics. It's not supposed to be partisan, but it's really become political. Would you agree with that? Has the Supreme Court become pretty political? Yeah. So some of the suggestions that have been made to fix that are change the Constitution so it's not up to the Senate to confirm. Create an independent judicial board made up of retired judges who picks the nominees based on qualifications, experience, knowledge, etc., regardless of political identity. The other change we could make is, instead of making it a simple majority to appoint a Supreme Court justice, maybe change it so it has to be a 2/3 majority vote. Make it so the majority party can't just ram someone onto the court. Because it used to be more bipartisan. When the late Justice Ginsburg was confirmed in 1993, I believe this was, she was confirmed by a vote of 94-6. We don't see that anymore, right? We don't see that clear bipartisan majority anymore. So maybe that would be a way of trying to fix that. Make it so that it has to be a bipartisan majority rather than, well, we're the party in charge, so too bad for you. Yeah. Because the court is supposed to be able to hold Congress and the president accountable. But how do you do that if you're beholden to the president for appointing you in the first place? It's a little tricky. Okay, so just as a reminder, the research paper is due tonight by 11:59 p.m. in Blackboard. Any questions on the research paper? Any last minute questions? Anyone online have any questions? Okay, if for some reason Blackboard isn't working tonight, just let me know. And if you've already turned in your paper, then you're good to go. On Thursday, we're going to start talking about social policies like taxation. So read the first half of chapter 16. If you have any questions between now and Thursday, feel free to email me or call or text my cell phone. Otherwise, enjoy the rest of your day.